Call the case. This matter is entitled People of the State of Michigan versus William E. Benz. File number is 2425114FC. This is a 45th Circuit Court matter. Mr. Benz started this journey in the district court several years ago in front of Judge Pattison, and the matter was bound over to circuit court on a waiver or preliminary examination. My name is Judge Jeffrey Middleton. I'm here by special assignment on behalf of Judge Paul Stutzman. Judge Stutzman has announced that he is undergoing a course of cancer treatment, hopes to complete the treatment and return to full service, but for the time being, we will be filling in for these kinds of things. I am cross-sworn. All four of us are cross-sworn to handle assignments for one another, and several times a year I'm called upon to do a circuit court matter. So you have me. What we have here is a motion by the people to revoke bond in this case. The people are represented by Elish Gallagher. Am I saying that correctly?
Elish Gallagher, Your Honor.
Elish?
Elish, yes.
Elisha. All right. Elisha Gallagher is here from the Attorney General's office. Luke Knopfinger is here on behalf of the defendant, and Ross Truckee as co-counsel in this matter. This matter was assigned to the Attorney General's office during Prosecutor Marvin's term. He asked the Attorney General for assistance in multiple criminal sexual conduct cases, maybe 6. This is one of those. It precedes Prosecutor Davis's tenure, but plaintiff people are represented by the Attorney General. Mr. Benz was originally charged in the district court file number 231412. Charges are serious. It's alleged that he did engage in sexual penetration with a child under 13 years of age. 2 counts. That is a felony punishable by up to life imprisonment. He was also charged a 3rd count and a 4th count. And he was also charged as a 4th habitual felony offender, requiring a mandatory 25-year sentence if the defendant were convicted of any of these counts. The matter was bound over in 2024, I think, in front of Judge Pattison. And the matter, it's embarrassing to me, frankly, that this case is a 2023 case and we're here in 2026 and it's still pending, but I don't have any control over that. All right, Mr. Benz, you okay? No. Well, I got the Kleenexes there. Yeah, serious charges, serious ramifications of a conviction. The prosecutor, through the Attorney General's office, has moved to revoke your bond. And they filed a pleading with a number of exhibits attached. Ms. Gallagher, I probably know Mr. Benz myself for 20 years or more.
I got my wife is right there. That's who the
All right.
That was on.
That's a good. All right. So why don't you state for the record the people's reasons for requesting to cancel the bond?
Thank you, Your Honor. For the record, and I did lay out some of it in my motion, but specifically, and I guess most troubling to me, is that when defendant was on bond, he was being monitored by a tether. This was after multiple times that his bond had been revoked. There was a period of absconding, and that's laid out in the people's motion. However, this charge on November 26th of 2025 in Kalamazoo County was for violence against a female, an intimate partner. They did charge a domestic violence 3rd case on this case. Due to committing violence against a significant partner, he was able to get out of the tether. And then when he was released, never again was subject to tether monitoring. Your Honor, interestingly, when we look
All right,
at
so
the
what you mean is he went into custody and they took the tether off while he was in custody in Kalamazoo County. Is that correct?
Yeah.
correct,
Okay.
and let him leave Kalamazoo County without putting the tether back on, with the understanding he was going to get the tether put back on, and never
All right,
did.
well,
So
let me
this-
stop you for a minute, just for the record. Did the Kalamazoo County case result in a conviction?
It did not, Your Honor. From lack of participation, they decided to follow the victim's wishes. However, I did notice in my other acts notice, and I did get the video surveillance and body cams that I've shared with defense from Kalamazoo County, and some of the assault of nature that was on video from that domestic violence third charge. That did not result in a conviction.
Okay, go ahead.
Thank you, Your Honor. Notably in the report from pretrial supervision, it says that when he was on the device, there were no violations. However, respectfully, I would think that, you know, the assault of charge would be a violation of bond, which he apparently did while on the tether. So it does not seem that the tether was enough to stop any kind of assault of behavior with significant others. Further, Your Honor, the defendant's history of not only failing to appear, but also his history with drug use and documented convictions for aggravated assault, assault and batteries, attempt, resisting and obstructing, a slew of disturbing the pieces, but more importantly or more troubling, multiple dismissed domestic violence cases, and also two that remain a conviction pled down from a strangulation case. As Your Honor is aware, this is a very serious crime, and being on any type of bond and in the community is a privilege with regards to when you are charged with a criminal sexual conduct in the first degree. I believe that this defendant has shown that he is not able to be in the community with any kind of supervision that would protect the public and adequately assure that he is appearing for court. Further, not only was the tether not placed back on, but the pretrial service report indicates multiple attempts of contact were made and no phone calls were returned. He had not been even checking in as required. And then we did get an updated report that said on 3/4 of 2026, he stated he didn't have a working phone and is homeless. It's not setting up ideal situations. If he can't, you know, remain on tether and have the rest of the public safe, I just think it's not appropriate at this point. And we'd ask for his bond to be canceled. Thank you.
Are you referring to the report from our community corrections coordinator, Tiffany Howe? From earlier this month in March, is that correct?
There was one from report dated March 6th of 2026, Your Honor. There was also one dated report January 28th of 2026. I believe I attached the January report as exhibit 2 to my bond motion.
Well, the more recent one you referred to, March 6th.
Yes.
Is doesn't say who authored it, but Tiffany Howe, where you indicated he did contact the office on Wednesday, March 4th. He does not currently have a working phone and is homeless. He's been staying at the shelter. All right, thank you. That's, I think, in the file as an exhibit. Who's going to speak on behalf of Mr. Benz?
I can make a couple comments, Judge, and then ask Mr. Truckee to maybe play cleanup here. A couple things is the case was dismissed in Kalamazoo. Just yesterday, the day before, I did receive a lot of body cam footage. I didn't have the surveillance footage to review repeatedly throughout the case. And, you know, this is kind of awkward relitigating maybe a domestic violence that was dismissed, but Mr. Ben's very clear. He says he was assaulted first and it was in response to that. haven't had an opportunity to review that surveillance footage. He did spend 30 days in jail because of that case. Kind of interestingly too, I note too that Tiffany Howe does say that the electronic monitoring, I guess there's some attempt to have him placed back on the GPS monitoring. But then at the end of her report, she said it is not considered best practice to maintain an individual on GPS monitoring for an extended period of this length, absent violations or new concerns. I guess maybe that's the violation of the new concern. I don't know. This case has been pending for some time. There was just a 768 notice that we're preparing an objection to filed just recently. I would note, and I think this is important because MCR 6.106 is invoked here, that due to the nature of the charges, the court can deny bond if the presumption is great. That's important, Judge, because, and I don't know how much the court is familiar with the case. I assume there's an affidavit.
That's all I do know about it. I didn't handle the case at the district court level. Judge Pattison did, but I have looked at the affidavit of probable cause that accompanies the pleading.
And I would note a couple things in there, Judge. This is a delayed disclosure from 2023 based on allegations in 2015 and 2016. So there are a lot of things going on here. There's a couple protective orders in place. So there are some medical records and some other things I can't really share with the court, but we're litigating those points. So I think what the court would have to find is that the presumption of guilt is great, and then the court would then have to make a finding that the second part of that court rule that either there would be a risk of harm to another individual or the public at large. There was a period of time where Mr. Benz was not making, that he had failed to appear. There have been a litany of status conference, motion hearings, and other things where he has appeared for those things.
I tried to follow the history of this case, and like I said, I'm embarrassed how old this is, but there have been probably more than a dozen court hearings in this matter.
Yeah, that's true, Judge. And underlying all of this too, Judge, is just, well, simple and honest in poverty, right? Where there is someone is living at the homeless shelter, struggling to find secured housing. There have been a long list of phone numbers that have been provided and then been discontinued. So Mr. Benz is here today. He has appeared at numerous court hearings. There is a difference between, there was a bond that was set. Many of the things stated in the bond motion too were known when the bond was set initially. He was able to post that bond, and now the ask, Judge, is to just throw it out altogether and cancel the bond. Court has a wide range of options before it. I think asking to have the bond canceled is somewhat of an extreme ask given the circumstances. So defer to my colleague. Thank you.
All right, Mr. Truckey's quite eloquent. Let's hear from him too.
Thank you, Your Honor. In response to the state's argument, first, there's a hint that bond is a privilege, and I would object to that consideration. Remaining on bond may be a privilege, but it's also a right that our founding fathers established for us. Mr. Benz posted a bond, and he has attended the vast majority of the court dates. There was an issue in November, I believe. Judge Stutzman heard about that at a status conference earlier this year, and he made his determination on that at that time. This domestic violence investigation was also known at that time. A formal motion, I don't believe, was brought before Judge Stutzman, but this was all in the air at the last status conference. It wasn't a big surprise. And Judge Stutzman allowed Mr. Benz to continue on bond. He's been participating in Ministries with Communities in Kalamazoo. That is a resource he's used to stay in contact with me. He's been in regular contact with me. He's not absconded from the state. He's not disappeared. He wants to continue to litigate this case. It's a complex case with old allegations. And again, as Mr. Knopfinger alluded to, very technical and private details that we may be subject to a protective order. But All we're asking is that Mr. Benz continues doing what Mr. Benz is doing while this case is prosecuted.
Work every day.
The domestic violence case was dismissed by the prosecutor in that jurisdiction. I don't have documents saying why. I don't have a declination. I don't have a nollie pros order in front of me. The prosecutor in that jurisdiction elected not to pursue charges after Mr. Benz did spend some time behind bars. Of note, the alleged victim in that matter was also taken into custody on that day and released shortly thereafter. She's here today. Also, there's some conflation. There's a criminal sexual conduct charge against a minor, and I don't want the conflation of between domestic violence charges with intimate partners to kind of bleed over. Those crimes, I suppose they rhyme with each other a little bit, but they're not the same. And so I want the court to make sure to kind of consider them distinctly. But with the age of this case, and frankly, with some of the matters going on in the circuit court, there's a concern I have that this may be victim of delay for reasons outside of any of our control. And I would hate to see Mr. Benz spending a prolonged period in custody awaiting his trial. So that's my piece. I'd ask that you deny the motion. If the court would want to impose further conditions, including electronic monitoring, that's understandable. Mr. Benz is employed, so he does have positive people that are in his life as well, besides just the folks at the trial. But we'd ask the court to consider those options short of revoking his bond and taking that extreme step of remanding into custody. Thank you.
Mr. Benz, where are you employed?
Through Open Door Construction.
Which is through the homeless shelter?
No, actually, I went out when I first came to Kalamazoo. I went to a temp service and I met a guy that does construction. He has his own business. Just starting out, I helped build the courthouse in Kalamazoo, and I helped build the Raising Cane on Westmead. He's a commercial contractor. I've been with him. He's actually been with me through this whole thing. I mean, he's been awesome. Been good. Been my boss.
Then why are you in the homeless shelter?
Just because of the traveling. I don't have a car. I can't. My boss picks me up for work every morning, so I'm just trying to get up on my feet, and with the allegations that are put on me, it's kind of hard when they want to run in my background.
If I gave you a drug test right now, this minute, what would it tell me?
Probably for weed.
Yeah, for meth?
You said for weed, right?
Just weed. Possibly.
All right.
But I really, that ain't nothing that I have in my.
That's a underlying theme here. Pink elephant in the room. You've been struggling with methamphetamine for a while. Now, this crime allegedly occurred between 2014 and 2016. You've been here multiple times between then and now.
I'm not trying to do anything.
In 2023, I handled file 23653FY, and it was a very unpleasant domestic assault. I believe it was charged as domestic violence. Third offense, it was reduced to a domestic violence, 2 counts. You assaulted your partner, Ms. Yoder, and holding her down on the bed, slapping her repeatedly, tearing her clothes off, shoving her down the exterior steps. I gave you 60 days jail in May of 2023. In 2022 to 2023, the interesting thing is that you just got out of jail and filed 23419FY. You were charged with possession of methamphetamine and some motor vehicle offenses. Pled to use of methamphetamine. I gave you a huge gift. 13 days credit, 13 days lay out of jail. you were to pay your fines by August 1st, which you paid 0 of. When it came time to posting a $15,000 bond, you had money. When it came time to paying your court fines and costs, you don't do so good. You have $2,059.32 worth of unpaid fines and costs. That methamphetamine case that I gave you a break on, you paid none. Malicious destruction of a building, $497. Careless use of a snowmobile, I remember that one, $192, and a bunch of traffic stuff. So, all right, I let you out in March. In April, you beat up Miss Yoder and you go to jail for 60 days. In May of 2023, I think you got out sometime in June. Then this case was charged in July of 2023 is when the trooper signed it. So I'm not sure exactly when you got arrested. Although let's take a look at that. I have the bond. So you went to jail in March, you went to jail in April, and then you got arrested on this in July, I think.
The instant case arrest would have been in late November, early December of
24.
2023.
I'm looking for the bond form. I had it. The defendant had failed to appear a couple of times. Frankly, I was surprised that he posted the $15,000 bond. It was set by Magistrate Autumn Kiefer. And the defendant did post it. Then it got revoked. Maybe twice. I had the bond. You're not doing better, Mr. Benz. I suspect if I gave you a drug test right now, it would show positive for methamphetamine, and you acknowledge it would be positive for marijuana. You got some indeterminate job and you're living in the homeless shelter. This is not a matter of ensuring that you show up for court. It's a matter of protection of the public.
Just the message that I had.
All right, well, just your lawyers don't want you to just say things at random. Here's the bond. All right, it was set the amount of $15,000 cash or surety, and it has a number of conditions which are on every bond, and they added some. The conditions of your bond are as follows. These are printed right on the back. Make reports to the court agency as specified by the court or the agency, which would include we don't normally eat or drink while we're in court, so I'd ask you to leave the coffee set aside. We'll pretend like we're in a real hearing.
Apologies, sir.
Make reports to a court agency as specified by the court or the agency, which that would include the reporting to community corrections, which right now is off the rails. Not use alcohol or illicitly use any controlled substance. Participate in a substance abuse testing and monitoring program. That was not ordered, but if it was, they ordered 2, 5, 8, and 9. So not use any drugs, comply with the restrictions on personal association of place, residence, or place of employment, not to have any contact with the complaining witness. Condition 8, continue to seek employment. Condition 9, continue to begin educational appointments. The bond also says you shall not harass, intimidate, beat, molest, wound, stalk, or threaten to engage any conduct that would place any of the people in danger, specifically those people. This is the terms and conditions of the community corrections supervision. I will personally appear for any examination, arraignment, trial, or sentencing, will appear at such times and places as may be directed by the district court or the circuit court. If I am represented by an attorney in this case, any notice to appear may be given by my attorney in place of personal notice to me. I will abide by any judgment entered in this case and will surrender myself to serve any sentence imposed. I will not leave the state of Michigan without permission of the court having jurisdiction over my case if I am on a felony bond. I will not commit any crime while released. I shall immediately notify in writing the court having jurisdiction over my case of any change in my address or telephone number. I will abide by any other conditions described in the face of this form. I understand if I violate conditions 12 or 13, I am subject to arrest without a warrant and may have my bond forfeited or revoked and new conditions of release imposed. Now, the conditions 12 and 13 are not assault, harass, intimidate, beat, molest, wound, or threaten any named person or persons on the face of the bond. And 14 is satisfy any injunctive order. Now, the person that you allegedly molested, beat, or wounded was not a person named in the complaint. But I understand that if I violate any of the terms and conditions of this bond, I will waive extradition if I'm arrested in another state. So you got arrested for a domestic assault. I wasn't clear if the Kalamazoo charge was a felony or a misdemeanor. You do have several previous assault charges here, including the one I gave you 60 days for, which I frankly thought that was a gift. Then just before that, I'd given you 13 days, which was a gift. The statute referred to, or the court rule, which is 6.106, it deals with pretrial release. Now, one of the issues here, this is a serious charge. This is a capital offense, 4 counts of criminal sexual conduct, first degree, which is punishable by up to life imprisonment. It's not breaking into somebody's shed in the backyard. It is a capital offense as a 4th habitual offender. So you take into account the actual nature of the charge. 6.106B (1)B, a defendant charged with criminal sexual conduct in the first degree, which is this, armed robbery or kidnapping, if the court finds that proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. I don't think you're likely to flee, but I'm not sure I've got clear and convincing evidence that you're not going to be a danger to any other person. Just before you got arrested for this, you seriously beat up your previous girlfriend. And I gave you 60 days in jail. A while later in the same year, you got arrested for this charge. It is true that you have not been convicted of the assault charge in Kalamazoo. To be convicted of that charge requires proof beyond a reasonable doubt. And for reasons that probably were apparent to Kalamazoo County, sounds like they had lack of cooperation. They dismissed the case after 30 days in jail. The victim was Catherine Gartner, also known as Catherine Louise Gartner. Is that you?
Yes, Your Honor.
Or you refer to her as your wife? You're not married.
No, no.
All right. She apparently isn't very concerned about it, but what you told the officers was on the body camera, you think I assaulted someone today, just wait till I get out. I'm gonna get out tomorrow on this bullshit charge, and I'm gonna be back on the streets tomorrow, and I got something for your bitch ass. I got something for Catherine when I get out tomorrow. I got something for you, you nigger bitch. I'm not convinced by clear and convincing evidence that you're not a danger to other people. I'm embarrassed that you got arrested for a serious domestic assault charge in Kalamazoo while you've been on bond on this case for 2 years, 3 years here in St. Joseph County. I also haven't made a finding that you're positive for drugs. You've acknowledged marijuana, which is lawful for adults for recreational purposes, but I think marijuana is still in the equation. You also failed to re-register and advise the court of your address after you got out of jail. You're not presently on any tether supervision. We don't know what you're doing. You're not being drug tested, and you're living in a homeless shelter in Kalamazoo. And you talk that way to a police officer in Kalamazoo, threatening him, a complaining witness, and not comporting yourself very well while you're on our bond on a criminal sexual conduct charge. Mr. Benz, I won't be the judge to try this case. I'm not sure who will be. I'm not sure if I'll live long enough to see this case go to trial, but I'm canceling your bond. You're out on a capital offense as a fourth habitual offender. You're not in compliance with your tether requirements. You've got $2,000+ of unpaid fines and costs for previous assaultive and drug offenses here in my court. And you talk like that to the police officers.
I was just angry.
Yes, don't. You're going to jail. Your bond's canceled. A circuit judge can review it for further hearings. And I do apologize because this case is a long way from getting tried.
I would never touch my cheek.
All right, well, the fact that you'll never touch any, what did you say, any children? I don't know what you said, but don't say anything else. Take him back into custody. His bond is canceled.
I love you, babe.
Judge Middleton, this is set for trial
No,
on April 28th.
say that again.
This is set for trial on April 28th and it's the first
All
case
right,
to go.
okay. All right, that's Jill Ross from the circuit court. The matter is set for trial for April 28th. So we are really not talking about that.
Billy, I got you here. I love you, sweetheart. Don't worry, Billy. We'll figure it out.
I thought you had sent me an order canceling the bond, but I couldn't find it.
No.
Did you do one?
You guys didn't even let me say anything on his behalf.
We're still on the record, so you guys have a seat for a minute while we finish up and then you can talk. Did you send an order canceling the bond?
Would you like me to do one, Your Honor? Apologies, I did not.
Well, we had an earlier one. Jill, can you do one?
Yes, I can.
All right. For the reasons stated on the record, the bond is canceled. I feel better knowing there's an April 28th trial date. I don't think he's a flight risk, but I'm not convinced that he's not a danger to other members of the public. All right, thank you. We'll prepare the order here by the court.
Appreciate it, Your Honor. Thank you.
All right, thank you.
Apologies again for the drinking, Your Honor.
Well, you didn't know. People tend to just be informal when they're in their office, and but that's generally not a good form. All right,
Understood,
thank you.
moving forward.
Nice to
Thank
meet you. And
Thank you.
good luck as this case goes forward. Thank you, gentlemen.
Middleton, you said April 28th was the trial.
As this hearing comes to a close, the judge's decision sends a powerful message that the court takes public safety, accountability, and bond conditions seriously. What began as a bond review quickly turned into a harsh reality check when concerns about missed supervision, prior violence, drug use, and threats made while on release all came under scrutiny. Despite the defense arguing for another chance, the court ultimately determined that the risk to the community outweighed the defendant's freedom, resulting in his bond being revoked and a return to custody. It's a reminder that every word, every action, and every decision made outside the courtroom can have major consequences inside it. What do you think about the judge's decision in this case? Did the court make the right call, or should the defendant have been given another opportunity to remain free while awaiting trial? Share your thoughts in the comments below. We read every comment and would love to hear your perspective. If you enjoy real courtroom drama, powerful judge reactions, and cases that reveal how the justice system works in real time, make sure to like this video, subscribe to the channel, and turn on notifications so you never miss our next courtroom breakdown. Thanks for watching, and we'll see you in the next case.